I am delivering the lecture series on the main topic of bringing legal representative of deceased party in a suit on record. I have divided this main topic into various subtopic, and regarding that various subtopic I have already uploaded 6 lecture in 6 video part so far. Now this is the 7th part, and the subtopic is now that a new and different plea is taken by a substituted defendant, that is legal representative, thereby filing his additional written statement. So, in case where the original defendant has died during the pendency of suit, and in his place, when his legal heirs is substituted, the question is that whether that substituted defendant can file additional written statement and thereby take a new and different plea than that of the original defendant, than that of which that original defendant has taken before the court. With respect to this topic, I am referring one judgment of Jharkhand High Court. It is reported in All India Report 2005, Jharkhand, page 109. This judgment is given by the Jharkhand High Court in the writ petition, and parties before the High Court in this writ petition is Shyam Sundar Bajaj versus Sanwarmal Jalan. Shyam Sundar Bajaj versus Sanwarmal Jalan and others. Here, that respondent in this writ petition, Sanwarmal Jalan, he is a plaintiff in original suit, and that Shyam Sundar Bajaj is the substituted defendant in the original suit. The facts of this case is that here this petitioner before the High Court in the writ petition, Shyam Sundar Bajaj, he is a substituted defendant number 2 in the suit. Which suit? That suit is filed by that Sanwarmal Jalan in the year 1997. That suit is eviction of tenant from the tenanted premises, eviction suit. So suit is for eviction of tenant from the tenanted premises. That suit has been filed in the year 1997 by that Sanwarmal Jalan. That said suit for eviction was filed by the plaintiff respondent here in writ petition against one proprietorship firm. That suit was filed against one proprietorship firm, sole proprietorship firm. Its name is Messrs. Jethamal Satyanarayan. Suit is filed by the plaintiff praying for a decree for eviction, ejectment of the defendant from the suit premises, and this suit is filed on the ground of default made by that tenant in making payment of rent. So who is tenant? That sole proprietorship firm, Messrs. Jethamal Satyanarayan. And what is the ground for filing this suit? Defendant tenant made a default in making payment of rent. So it is a case of plaintiff that he is a landlord and defendant is tenant in a portion of suit premises consisting of two shops. Then that sole defendant, Messrs. Jethamal Satyanarayan, that is a sole proprietorship firm, sole defendant, through its proprietor, Mr. Satyanarayan Bajaj. Mr. Satyanarayan Bajaj appeared and filed written statement contesting the claim. So that sole defendant, Satyanarayan Bajaj, appeared before the court and filed his written statement. What was his defense in the written statement? His defense that means he did not dispute that he is a tenant and that plaintiff is the landlord of that tenanted premises, two shops. It is not disputed, but what is his defense? Why he was not paying the rent why he made default in making payment of rent. His defense was that plaintiff was forcing the defendant to enhance the rent at exorbitant rent, excessively high rate, and plaintiff also forcing the defendant to pay heavy amount of pagdi, that is one sort of deposit which may be unrefundable, and therefore the demand of that plaintiff was illegal. This defendant has refused to accept the same, and so he was not paying the rent because plaintiff is asking for the excessively high rent from the defendant. Now, during the pendency of that suit, that sole proprietor of the defendant firm, Mr. Satyanarayan Bajaj, died, and in his place, his legal heirs were substituted as defendants. His legal heirs include here the petitioner before this High Court, that is Shyam Sundar Bajaj, and that petitioner was included in that suit as a defendant number 2. Then that defendant number 2, who is a substituted defendant, he filed additional written statement contesting the claim of the plaintiff. But in variation of the original written statement, that substituted defendant set up a case of independent tenancy right of one Ram Karan Bajaj, who is another son of Satyanarayan Bajaj, over the portion of suit premises, and that case of independent tenancy right of that Ram Karan Bajaj, this matter was not pleaded in the written statement of the original deceased defendant. Original deceased defendant is Mr. Satyanarayan Bajaj. Thus, that substituted defendant, through his written statement, he is making new plea regarding independent tenancy right of that another son of Satyanarayan Bajaj. Therefore, the trial court passed the order and held that said additional written statement filed by that substituted defendant number 2 has raised a new and different plea regarding the tenancy right of Ram Karan Bajaj, which plea is not permissible. That new and different plea is not permissible. Therefore, the trial court rejected said additional written statement. And against being agreed by this order, that substituted defendant number 2, he came before this High Court, thereby filing the writ petition. So, before this High Court of Jharkhand, this Shyam Sundar Bajaj is a substituted defendant as a writ petitioner. So, when the matter came before the High Court, that advocate who is appearing on behalf of that substituted defendant petitioner, he contended that the order passed by the learned court below, that is trial court, that order passed by the trial court. What was the order passed by the trial court? Trial court rejected that additional written statement of that substituted defendant. So that advocate who is appearing before the High Court on behalf of that substituted defendant, that is petitioner, he contended that trial court order passed by the trial court is wholly erroneous and it is contrary to the law. And in support of his argument, he relied upon one decision of the Honorable Supreme Court in one case of Balkishan versus Om Prakash, which is reported in All India Reporter, year 1986, Supreme Court, page 1952. So, in that case, the Supreme Court also observed, reported case of Balkishan, Supreme Court observed that in that case also, the facts are such that Balkishan was the substituted defendant of the original defendant Musaddilal. That Balkishan was the substituted defendant of the original deceased defendant of defendant Musaddilal, and in that case also one suit was filed for the eviction of that tenant who was tenant in that reported case. Musaddilal was tenant of one's tenanted premises, and the landlord of that tenanted premises has filed a suit for eviction against that Musaddilal, and in that suit that Musaddilal also appeared and filed his written statement, and he admitted his relationship with the plaintiff landlord as a landlord and tenant. But during the pendency of that suit, that Musaddilal died, and in his place Balkishan was the substituted defendant. So Balkishan is the legal representative of that deceased defendant Musaddilal, who was a tenant in that case. So in that case also, that Balkishan appeared before the court, and he also contested the suit of the plaintiff landlord. Suit was for the eviction. He contended that, Balkishan contended that he himself was in a position of the tenanted premises as a trespasser. He himself was in a position of the tenanted premises as a trespasser, and therefore that suit for eviction was not maintainable. So that issue of trespasser, that plea of trespasser, was not taken by that original deceased defendant Musaddilal. On the contrary, he admitted that he was in possession of that tenanted premises as a tenant. But after his death, when his legal representative, namely Balkishan, appeared before the court, he took new and very different plea. He said that I am not the tenant, but I am trespasser of that premises in question. I am not a tenant, but I am a trespasser. I am having possession of this premises as a trespasser. I am having independent right of possession as a trespasser, and therefore the suit for eviction against him is not maintainable. So on this background, that Supreme Court in this reported case of Balkishan, it is observed by the Honorable Supreme Court that it is true that it is possible for the court in an appropriate case to implicate the heirs of deceased defendant in their personal capacity. In their personal capacity also, implicate the heirs of deceased defendant in their personal capacity also, in addition to bringing them on record as a legal representative of deceased defendant. So Supreme Court observed that legal representative may be added in the suit as a legal representative of the deceased defendant. Besides that, they can also be implicated in the suit in their personal capacity. Why? To avoid thereby a separate suit for a decision on independent title. So Supreme Court also observed that it is possible to implicate the heirs of the deceased defendant in their personal capacity also, in addition to bringing them on record as a legal representative of the deceased defendant. So this reported case of the Supreme Court, it was relied upon by that advocate who is appearing before High Court on behalf of that substituted defendant in this present case. Then, after hearing the parties, High Court concluded that and observed that in this present case, this Jharkhand High Court, it is observation of the High Court, Honorable Justice of the High Court, that the plea which is sought to be taken by the petitioner, that is substituted defendant, the plea which is sought to be taken by that petitioner by an additional written statement is new and different from the original case of deceased defendant. Why? A case of an independent tenancy in favor of Ram Karan Bajaj in respect of portion of suit premises cannot be set up by the substituted defendant who is a petitioner as a legal representative of the deceased defendant. That case of independent tenancy in favor of that Ram Karan Bajaj in respect of that suit premises cannot be set up by that substituted defendant as a legal representative of the deceased defendant, because no such case was pleaded in the original written statement filed by the deceased defendant. And regarding that case law upon which that advocate for petitioner relied upon in support of his argument, advocate appearing on behalf of that substituted defendant, regarding that case law, this High Court observed that regarding that case law, in one another case, the Honorable Supreme Court followed the principle laid down in said case of Balkishan versus Om Prakash. That another case of the Supreme Court, which is reported in All India Report, year 1995, Supreme Court, page 1653, and parties before that reported and refer case before the Supreme Court is Vidyavati versus Manmohan. So in this case of Vidyavati, the Supreme Court has followed the principle laid down in their earlier decision in the case of Balkishan versus Om Prakash, holding that the legal representative having independent right, title and interest in the property has to get himself impleaded. Legal representative having independent right in the property has to get himself impleaded in a suit as a party defendant for setting up his own right, title and interest. So after following the principle laid down in Balkishan, Supreme Court in this case of Vidyavati, reported in the year 1995, Supreme Court has observed that it's okay that substituted defendant can file additional written statement and he can take a new and different plea, but that legal representative who is having independent right, title, he has to get himself impleaded in a suit as a party defendant for setting up his own right, title and interest. So in that case of Vidyavati versus Manmohan, Supreme Court further observed that in such case, it is always open to the concerned legal representative to file an application under Order 1 Rule 10 of the Civil Procedure Code, praying his addition as a party in his independent capacity. And thereafter to file an additional written statement asserting his own right. So Supreme Court held that if that substituted defendant of the original deceased defendant, he wished to take a new and different plea, he wished to put forth his own claim, then in that case, firstly, he has to make an application, he himself has to make an application before the trial court to implead him as an independent party. He has to make that application under Order 1 Rule 10 of the Code, bring his addition as a party in his independent capacity. Because plaintiff will bring him on record as legal representative of the deceased defendant. For that, plaintiff will make application under Order 22 Rule 4. But where that substituted defendant want to put forth his new case, different plea, he want to take a different plea, then he himself has to make separate application before the court under Order 1 Rule 10, bring his addition as a party in the suit in his independent capacity, and then only he can file additional written statement taking new and different plea. So it is held by the Supreme Court in this Vidyavati versus Manmohan, reported in the year 1995. Therefore, after referring to this decision of the Supreme Court in the Vidyavati case, this Jharkhand High Court in this writ petition held that there is nothing on record to show that substituted defendant has made any such application before the trial court seeking his addition as a defendant in his own capacity before filing his additional written statement for taking a new plea as a defense. So nothing to show on record of the trial court that he has not made any such application under Order 1 Rule 10 to make him to add him as a party defendant in his own capacity. So nothing is there, nothing such has happened before the trial court. Therefore, in this writ petition, High Court held that ultimately this writ petition preferred by this substituted defendant Shyam Sundar Bajaj, this writ petition is dismissed. But High Court further said that substituted defendant if so otherwise, may file an application under Order 1 Rule 10 of the Code, seeking his impediment as a defendant in his independent capacity, which may be considered by the trial court below in accordance with the law. So, High Court also said that it is open for you. We are dismissing your writ petition, but it is open for you to file a separate application before the trial court under Order 1 Rule 10 for praying for your impediment as a defendant in your independent capacity. Your application may be considered by the trial court on merit. And if suppose the trial court allowed your application, and if your impediment is allowed, then it will be open for you to set up your own independent defense or to take any other plea available to you in your independent capacity as a defendant. So, after giving such an advice to that petitioner substituted defendant, High Court has dismissed this writ petition. So, what is the conclusion? If any substituted defendant want to take altogether different and new plea than that of the plea taken by the original deceased defendant, then in that case, that substituted defendant has to file, he himself has to file separate application before the trial court under Order 1 Rule 10 of the Civil Procedure Code. So I stop here.